this is the second part of lecture 2. We're going to pick it up where we left it off as 2A, lecture 2A. We're in overruling precedent, but we're talking about, at this point is page 97, the four considerations that are particularly important when we're talking about this idea of going ahead and changing precedent. So the four, and then we'll go into great detail on them, is the hierarchical nature of authority, which is what I talked about in the last lecture, policy analysis, synthesis of incremental authority, and developing arguments for both sides. I'll give you the rationale for it, explain what it is, and we go from there. So the hierarchy of authority here, we talk about statutory and common law forms. There's a hierarchy here in descending order, right? The most important, as I said, is the legislature, and that can always override or modify some common law decision by enacting statutory law. So the legislative body produces the laws that are designed to deal with policy issues which come out of things that are occurring out there in the real world that need to be addressed. Okay, so the legislative body always has dominance over common law. Now, keep in mind, we talked last time about how they inform each other, but the presumption here is that the statutory or the statute doesn't violate the Constitution of the United States. When it violates the Constitution, then really the court itself can reject it, right? So basically, rather than just assuming that a particular issue is governed by common law, you have to first consider the possibility of the applicability of constitutional or statutory law. In other words, you just can't look at one in isolation. All right. Only after you've studied the letter of the statute, again, this is really the letter of the statute, the letter of the law, understanding the particulars of it, right? In context, the vocabulary, what it all means, what the intent is behind it. Within an act or a code system of some sort, you can fully, at that point, appreciate the interpretive case law on the matter. The following passages from an office memorandum illustrate the hierarchy of authority and the focus of statutory language. I'm going to give that to you. It's on page 97. We're going to talk about it. I want you to keep in mind that, again, we're going to take, a case and we're going to look at, exactly the fact pattern and what takes precedent here over, common law, Constitution, statute. So here we go. The Arizona Constitution, so it's a state constitution, and it's still the same there on the state level, grants municipalities the right to engage in industrial activities. Okay. So local governments can do industrial activities. The quote here is, the state of Arizona and each municipal corporation within the state of Arizona shall have the right to engage in industrial pursuits. Pretty straightforward. And that's the Arizona Constitution, and it's Article 2, Section 24. Not that matters, but that's what it is. The Arizona Public Utility Statute more specifically grants municipal corporations the power to acquire water utility corporations within or without its corporate limits. Okay, you can see why water is an important thing for any municipality. Okay, a municipal corporation may engage in any business or enterprise which may be engaged in by persons by virtue of a franchise from the municipal corporation, and may construct, purchase, acquire, own, and maintain within or without its corporate limits any such business or enterprise. That's a direct quote, right? That is the statute. That's the actual statute they came up with that they wrote in the law. In the beginning, they talked about the Constitution. Now we're down to the statute, right? Next is Arizona statute section 9-511, and it's listed there. The statutory reference to corporate limits appears without qualification to permit a municipal corporation to acquire utilities that provide service outside the municipality's corporate limits. Arizona case law, however, hints hints at narrower interpretations of the statute that recognizes two limitations on acquisition of power. First, it is unclear whether a city may acquire a water company's property outside the city corporate limits unless the city has shown that it genuinely and reasonably anticipates future growth into that area. Okay, so there you have the case law. So the first thing was the Constitution. Arizona Constitution grants the right. The statute then specifically granting the right is laid out next. And then the case law is coming next. You can see it, right? Constitution, statute, case law. Okay? Think about the other way up. You've got case law. It gets reviewed by, or could be changed by the statute, which must eventually pass muster with the Constitution. In this case, it's a state constitution. But the order is always the same. Case law. First, it is unclear whether a city may acquire a water company property outside of the city's corporate limits unless the city has shown that it genuinely and reasonably anticipates future growth into that area. And they cite a case. See Senda Vista Water Company versus City of Phoenix, and they give you the date, and it goes back to 1980. All right, so that's one case. There would be more. So you can see the relationship. Now think about the process there. First, we establish that there has been a right at the highest levels that have been authorized. Then let's talk about the statute, which is the specific elements of that, what we're going to do. Now, that has to be consistent with the Constitution. After the statute, we now want to support the argument with cases. In this case, I just give one case. We're on page 98. In theory, the principle of analyzing statutory language before turning to interpretive case law also applies to constitutional provisions, as illustrated in the example above, which I just read. Policy analysis. I can't stress enough. I think people, when they think of law, they don't think of policy, and that's a huge mistake. The only reason for the law is policy. I don't care if it's criminal law, I don't care if it's civil law, I don't care what it is. It's policy. If there were no problems ever, there were a perfect society, everyone got along, no crime, no disputes, nothing, then you wouldn't need the law. You wouldn't need policies to solve problems. So we get a problem. We say, we've got to do something about this because it's in some way harmful to the nation or whatever. We've got to do something about this. We come up with a policy. It would be good to do this. Goes to a legislative body. They're working through policy processes and what would work, what wouldn't work. They're debating this. They're going into committees. They're bringing in experts to talk about it. They're trying to get their mind around, and they come up with what they think is a reasonable resolution in the form of statute, right, to that problem. So they come up with a policy, formalized in statute, that should address that problem. Okay, that has to be consistent with the Constitution, whether it's state or federal. You can't violate that. Highest law of the land is going to be constitutional. But you don't really, that's there as a check of authority. But the statute can always be written to change that depending upon the document itself, the Constitution, and whether, it can be changed. Usually it's changed by amendment. Statutes are not amendments. Amendments are usually a higher order. They take more support from the legislative body in terms of people voting for it, or and states can do this pretty much any way they want, or whether it goes out to the various districts or whatever in a state, or if it's the federal Constitution, of course, it goes to states as well. So basically, constitutional requires more agreement, higher levels of agreement, greater numbers. A statute can deal with things that are constitutional, but they've decided that they're going to change the way something works, even if a case is in the middle and it involves that particular area that they've now written a statute in, policy-wise, that negates that. That case stops. It's moot because now the law has changed, right? Okay. So policy analysis, almost by definition, policy analysis lies to the heart of most lawmaking. If they say most, truth of the matter is you'd be hard-pressed to find something that doesn't fit into regulatory law or somewhere, okay? A legislature pronounces public policy when it enacts public legislation within the framework of applicable constitutions. Any such enactment represents elected officials' choice among alternative means to address a socioeconomic needs of the jurisdiction. So that's just what I said. You can see that that there's a relationship between these things that you can't change. Okay. Similarly, because common law rules are largely a reflection of judicial recognition of community needs, habits, and customs, they constitute the judiciary's pronouncement of public policy within the framework of constitutional and statutory law. In other words, common law, which is the courts, they rule in a way that's a reflection of all these things in society. In other words, they're not moving from it. So this is the second, in terms of the four constraints that we look at when we're dealing with all of this, right? These considerations. The second consideration is really very important. Okay, so I want to read this here, still on page 98 at the bottom. The arguments and conclusions that you develop in response to a policy question depend in part on the values that you apply to the problem. A policy argument may be based on moral, economic, political, institutional, or social values. In other words, some issues that we try and resolve in the legislative structure of writing a statute, that the arguments we make could be moral arguments, right? Could be economic arguments, could be political or institutional or any other social values. In other words, problems crop up everywhere, and we may have to look in various places to see how we approach them. It could be there's a moral element here that has to be addressed. There's an exercise which is on page 99, exercise 6-3, which I want to do to illustrate this point. State X has a criminal, quote, baby selling, close quote, statute, enacted in 1932, making it a felony to, quote, relinquish custody of one's child to another for payment, or to pay, or offer to pay another to relinquish custody of the other's child, close quote. What is the likely policy behind this statute, and what kind of conduct should be its primary concern? So in light of your understanding of the statutory policy, should a court interpret the statute to prohibit a surrogate mother from charging a fee for carrying the fertilized ovum of another couple to full term, surrendering custody of the child to the couple after birth? Does the analysis change if the one charging the fee agrees to artificial insemination of her own ovum, thus making her the biological mother? Should the state enact new legislation more specifically addressing surrogate mother contracts? So it starts off pretty simply. You can't sell a baby. Well, now science moves forward. What happens if you can not only use the sperm of a male and use the ovum of a female who's, let's say, not that person's wife or partner or what have you, and then the baby's born, and then they've paid that person, something $10,000, to carry the child to birth? Is that covered underneath this, the surrogate motherhood and baby selling issue? Where is that? Where does it lie? So whose child is it? And is this person really selling their child? What about putting a child up for adoption? Now, you're not receiving any money for that, and so is money really the issue here? But if the intention is you can't have a child, you need someone else's ovum, or you've decided that for whatever reason, you're going to use someone else's egg and someone else's sperm outside of the two people that are involved in going to be parenting this child. And then there's a third person that's going to carry it. You've got three people involved in the creation of one human being. These things get complicated. And so when we're talking about the idea that we have to look at the policy, as time goes by and science and technology and all that change the way we do things, there are moral issues that crop up, right? There are political and socioeconomic issues that crop up. So when we talk about policy analysis, we're looking at, does the policy we have, based on the structure of the statute, does it really address the issue we're facing? Think of the mobile home thing, right? You get a home, you get a car, or an auto. Now you got a mobile home, and now what do you do with that? What happens when people live in space eventually? We're always going to have problems, and we can only resolve them through logic and reason and through the structure of law, which we can change, so we can all have agreement about what's best for us. It's why you can have laws change based on violence, because it violates natural law. It has all kinds of implications down the road. All right, so the next consideration is synthesis of incremental law. And here, in few research, this is on page 99 still, in few research problems, is the legal standard set forth in a single, clearly controlling authority. More often, the legal rules that apply to a dispute are the products of a synthesis of multiple authorities. It's complicated. Now you just can't go to a book and look it up and say, there you go. There are multiple places that you would look to inform yourself about what you need to do. There are overlapping, sources that have to be looked at. It gets more complicated. And it gives a good example here. For example, Reconstruction era civil rights statute imposes liability for racial discrimination, right, in private contractual relations, but its application is tempered by constitutional interest in privacy and free association. There's a conflict, right? Thus, the true reach of the statute is defined both by the language of the statute and by values reflected in the First Amendment to the United States Constitution. Multiple sources means statutes, Constitution, case law may all say something somewhat different about the structure of this thing, policy, and that means you got to figure out, where the lines get drawn exactly, what controls what, and so on. So the synthesis of authority is particularly important in analysis case law, obviously, because they are depending upon that, right? Whether judicial opinions interpret statutory or constitutional law or develop common law, the resulting case law is inherently incremental. Courts express their legal analysis in the context of individual controversies, and holding in single judicial opinion is often too limited to support an accurate prediction about how the decision will influence subsequent cases. Okay. The court creates common law. All courts, they want to decide cases on the narrowest possible basis. They don't want to be overbroad. They need to be very, very specific about the facts they're choosing, and how they're putting those facts together, and what supports putting them together in that way to come up with this resolution, right? So the problem here is obviously you can't expect common law to really cover a broad spectrum. It's one of the reasons why you need a whole bunch of cases to get all the different facets, or not all of them, but enough of them to really make a decision about how something is going to work, how you're going to interpret that particular law. And the last consideration is developing arguments for both sides. Now, I really want to stress this. You cannot make an argument without looking at the counter arguments. You can't really be effective in making an argument unless you look at what else is what the other side's going to say. In other words, you need to be prepared and understand the other side's argument, what it's most likely to be, so that it can inform your argument, right? Because you are arguing against the other side. So you've got to predict, as best you can, how they're going to present their case and what the basis of their case is going to be, until you actually see paperwork, right? Because in an office memorandum, you're not really looking at anything just yet. You're not sure of exactly the way the other side's going to, what they're going to rely on and so on. But that can be figured out. So you have to really argue both sides to understand where the weaknesses are in your own argument. It's adversarial. So that means you really want to spend some time figuring out what the other side might say or do, right? Now, when you're writing a brief, right, which is informing, the court, or it's informing, the law firm itself, and of course it's informing you when you write it. When writing a brief, you should not take such a balanced approach. Instead, you must advocate your client's position and discredit your opponent's arguments, which means you need to know them. Nonetheless, to maximize your own advocacy, you must anticipate and evaluate the arguments of your opponent before you write your brief. If you're writing a memorandum of law, let's say an important client comes in to see one of the partners and says, you know what, this is going on. I'd like you guys to handle it. And I'd like to go after them and get them to stop producing, what we produce or what have you. So the partner, an important client, says, all right, we'll take a look at it. So they get all the facts and they give it to, some associate or someone in the firm. They say, this is an important client. Look into this issue. Here are the facts. Look into it and get back to us and tell us whether you think we should take the case or not. Some of you may have heard of IRAC, which we'll go over in a second, which is a way you approach all of this, or CIRAC. There are several. But basically, it's about getting the information organized in such a way that you can give it back to the partner or whoever's going to look it over and say, okay, look, these are our best arguments. These are going to be their arguments. Here's how we can counter that argument and that argument. But their third argument, we really don't have solid legal ground to stand on, and they could win on that. They could. You never say in a memorandum, we're going to lose or we're going to win. You say that it is likely that we will lose on this count. So, the recommendation then is that here we go. We're going to likely to lose. Partner or whatever looks at it and may say, okay, it looks like we stand a good chance of losing here, but I think maybe we could do this or do that, or this is an important enough client it's worth it for us to run it up the flagpole and just see who salutes. Maybe we'll get a court to go along with it. It's going to cost us a little bit of money. The client's willing to pay for it. They need to know we need to back them up on this. So even though we're probably going to lose, and I can tell that to the client, it's unlikely we're going to win for this reason. Do you want to proceed? I mean, if you want to proceed, we'll go. But you need to know ahead of time that we probably going to have a difficult time overcoming this particular issue or fact. So thus, to analyze a legal dispute effectively, you must develop arguments for both sides of the dispute. In synthesizing case law, you should consider alternative formulations of the general principles that emerge from a series of holdings. Case law, looking at cases and seeing how the court has interpreted things, where there isn't necessarily a clear statutory underpinning, but where the court sort of has applied things in such a way that you can see sort of how the court views these types of cases. So, and the reason why a series of holdings, you can't rely on any one particular case. Remember, multiple cases shape and create the entirety of the position of the courts, each case narrowly, but in the aggregate, give you a better sense. That's why you use case law when you're doing rule proofs and the like. You want to demonstrate through the cases that this is how the court interprets this particular, right? So going back and digging through cases is really important because that's going to support, because we want consistency in law. And if there are several cases in especially like in that district or in that state and so on, with similar fact patterns that are create decisions, you need to look at all of them and then you need to interpret them, and you need to see what cases there were that don't support your argument. You've got 3 points you have to make. You've got a whole bunch of cases that support point 1 and 2. Point 3, the other side has a lot of case law. How are you going to deal with that? Can you find other cases that might challenge that? Can you make an argument to the court that might win the day? So it's those series of going out and making a determination about exactly what you're going to do, what your approach is going to be. Cases are important. Remember, even statutes have to be interpreted once challenged in court, and those statutes are interpreted, as I said, and that means a series of cases, because they interpret things narrowly, is still needed to see how that particular statute has been used or has been defined by the court. You got to know what the court's going to say. You go into court, you want to know what the court has said about that issue. You want to look at their statutes, written statutes about how the court has interpreted those. Obviously, if there's a constitutional violation, then that case would be resolved differently, and you want to know that as well. You want to make the best argument you can. You want to be an advocate, but that means you need to know what the other side's doing. I'm going to make a sports analogy, for those that prefer other types of analogies. But in every sport, not only do you have a game plan, but your game plan incorporates how you can minimize the effectiveness of your opponent's game plan. Your opponent knows you're going to try and limit, the effectiveness of their game plan, and so that informs their own game plan. Maybe they alter it, they change it, whatever the case may be. So a lot of sports, before you even see any action on the field, both sides have tried to assess what's going to happen at any given moment, and then be prepared for it. That's why they'll change plays. They'll take different approaches to things. All sports, there's a lot of thinking going on behind what's happening on the field or the court or the ice. It's not just get out there and play. It's here's the fundamentals we're going to do, but now here's how we're going to apply them. Sports is always adversarial. I can't think of a single instance, unless there's been corrupt, betting, where one team or one person on the team says, "Gee, I hope the other guys win." That never. Well, it should never happen, otherwise it's not a competitive sport. All right, so I'll give you an example of this. This is on 100. For example, the common law of negligence imposes tort liability. Tort's a civil wrong. It's not a criminal act, right? Tort liability on a person who proximate cause, we refer to that as, proximately causes injury to another by breaching a duty of care owed to the injured person. Duty of care has to be interpreted. Do I have a duty to do this or not? So, for example, I'm walking across a bridge, right? Just a small bridge, and I look over and I hear this person screaming. They're drowning. Now I see them. Now I have a duty of care because I saw them. If I didn't hear them and I didn't see them, I can't be responsible in any way. But I have a duty to bring aid to someone that I know. Right? As soon as I know they're in danger of going to hell. Now, if I don't, I breached a duty. But what happens if I can't swim? If I see they're drowning, and I can't swim, I would drown going after them. Then it's an unrealistic duty, right? So it's these things, again, nothing is ever written in stone. All right, as a specific application of this tort law, physicians in most circumstances are liable for injuries caused by their failure to exercise reasonable skill and care in their practices, right? Medical malpractice. Suppose that the courts of the fictitious state of New Maine have developed an additional common law doctrine through their decisions in courts of strict liability, which does not require proof of negligence. You're liable, okay, for injuries resulting from abnormally dangerous activities. So, we're in a pub, and, you, because I would never do this, you stand up on the bar, and, you start throwing bottles of whiskey to people. And they catch you in a bottle, right? Comes crashing down, hits someone in the head, knocks them on the floor. We can make this really complicated. On the way down, they hit someone who then flies into the bar and knocks over something and cuts them, the domino effect. But let's just keep it simple. It hits somebody in the head, renders them unconscious, and so on. Now, the courts, right, have refused to apply this common law doctrine to medical practices, even risky or experimental ones. It's not going to be strict liability because even though it's risky, there's a need to take the risk, right? Think about Good Samaritan law. If you're trying to help someone that's in danger and it turns out to hurt them, should you be responsible? You were trying to help, and it turned out not to be help at all, but maybe even exacerbated the situation. Against this background of common law, right, New Maine has enacted a statute that makes any, quote, commercial enterprise strictly liable for injuries caused by its use of any toxic material. So now New Maine has said, you're strictly liable. It's on you. If you go ahead and use chemicals that cause injury that are toxic in nature, materials, not chemicals, materials. Now, suppose that a medical patient in New Maine died from a reaction to general anesthesia triggered by the patient's rare disorder of the nervous system. Much of the legal dispute in malpractice action brought by the deceased patient's estate and surviving family members might center on the applicability of the statute. Did it apply here or not? Okay, because if it did, then that changes the outcome. Assuming that anesthesiology is, quote, a commercial enterprise, because that's what it talks about here, right? In the statute, commercial enterprise strictly liable for injuries caused by its use of any toxic material, right? All right, so basically, without regards to the care that she exercised, in contrast, a companion claim based on common law negligence would require an injury, a duty of care that anesthesiology owed, right? And the degree of care that was actually exercised. And anesthesiologists should take care to do X, Y, and Z. Okay, so real example. Someone goes and there's a mole on their back and it looks like it might be precancerous. So they ask this person a whole series of questions. This is an actual case, right? A whole series of questions about his medical background. You all know. You go to the doctor, they want you to fill out everything, what drugs you're taking, have you any allergies? And he forgets to mention that he's taking this particular drug for something else. And so they go and treat this and they give him a drug. That drug basically, effectively, in combination with the drug the person was already on, results in blindness in one eye. Now, they gave them for the mole an injection, but they asked before, what medicines are you on? What are you allergic to? So they can then plan what to do. This person failed to put that down. They're not liable. Even though the outcome was horrendous, the person lost vision in one of their eyes. Nevertheless, you can't hold them responsible. There's no duty of care because they didn't know. You have to tell them. There's no way for them to know unless you tell them, right? Now, something has happened recently with the medical profession. A lot of these organizations have popped up where all these doctors join in a collaborative, corporation, whatever you want to call it. Never just skipped you for some reason. Anyway, if you're part of that, no matter where your office is, you can go on the computer and all that information pops out to you. So now, suppose they had those computers, they were part of this medical association, and they could have done it, but they didn't do it. They didn't bother to go in and check to see if this person was taking any drugs or if they were involved in any other procedures. Now, the information was there. One would think that they would have a duty of care, and they do, to look. They didn't look. Now they would be more likely to be liable, right? That sort of thing. All right. So those are sort of the considerations that we have. I want to talk about the application of law now to facts. So again, facts in the context of the event and the statutes, the relevant statutes in case law and constitutional law or regulatory law, those facts, we select out those that are important. You select the wrong facts, you come to a different place. So the first thing is looking at the fact pattern. For those that want to go to law school, it's fact pattern, fact pattern, fact pattern. Here's a whole bunch of information, and what is actually at work here, right? What's actually at play? So this is the over and over again. This is the case. So I'm going to give you an example from the bar exam. That is it's coming up in a few days. But I'm going to give you an example of a question from the bar. You'll see there's a fact pattern, and they ask a question. Now the fact pattern is relatively short. It's maybe 6 or 7 lines, and there are a whole morning and a whole afternoon spent answering these bloody things. So okay, so I'll just grab one at random here. So here's the question, right? The call of the question: is the court likely to admit the evidence of the orally agreed price of $100,000? Now I'll read the fact pattern. A buyer expressed interest in purchasing an industrial air conditioning system manufactured by the seller. The parties agreed orally on a price of $100,000 for the system, but continued to negotiate over several points. When all matters regarding the air conditioning system were finally settled, right, the parties signed a written agreement. It provided that the price for the system, which would be delivered on June 1st, would be $110,000. The written agreement, a lengthy form contract, did not contain a merger clause. The seller delivered the system on June 1st, but the buyer refused to pay more than $100,000, citing the earlier oral agreement as to price. The seller sued the buyer for the additional $10,000 under the written agreement. So they had an oral agreement of $100,000, right? And then when they wrote the contract, it said $110,000. So this is a contracts case, right? Contracts, they're content of meaning. So what are the important facts? Well, at the core of this, right, is the oral agreement prior to the written document, and the written document itself, contract, and the difference in price, right? The difference in price. And so here are the choices of the answers, right? A, there's 4 answers, A, B, C, D, E. Typically 2 answers go in one direction, no, and the other 2 go in the other direction, yes. Okay, so is the court likely to admit the evidence of the orally agreed price of $100,000? A. No, because the buyer assumed the risk of any mistake as to price. B. No, because the oral price term would contradict an express term in the written agreement. C. Yes, because the oral price term is relevant to whether the writing should be reformed. D. Yes, because the written agreement did not contain a merger clause. The merger clause is of no interest here. Okay, so what is of interest? The oral price when it in terms of the express term, the written price. So the answer here is B, that no, because the oral price term. So is the court likely to admit the evidence of the orally agreed price of $100,000? No, because the oral price term would contradict an express term in the written agreement. Okay, now let's just say they did. Then the whole offer acceptance function of a contract now could become an offer and then a counter offer, which means there's no contract. We got something that's written here, right? Okay, so this is what we call parole evidence, right? Rule states that evidence of earlier agreements in a partial integration cannot be considered for the purposes of contradicting terms in a written contract. You're just talking. Oh, $100,000. And then the written contract is 110. You could say 110 for any number of reasons, but you agreed to it, right? You agreed to it. So that's about parole evidence, and it's really about oral agreements versus written agreements. Now that's a pretty reasonably straightforward question if you know something about contracts. There are others that are not. There are others that are not much more complicated. Property and other things, and contracts get very, very complicated as well. All right, so I want to go back to application of law to facts. So you can see the fact pattern that you pull out the important facts. It's the oral, then the written, right? Understanding parole evidence and all of that. All right, so basic patterns here. At trial, the critical issues often are questions of purely historical fact. You're looking to find out, how the facts have been sort of applied in the past, right? How they've looked at them. Appellate courts will defer to some degree to the factual findings of a jury or trial judge. Therefore, issues on appeal inevitably contain a more substantial element of law. Typically, on appeal, the appellate court is going to kind of accept the facts that have been pulled by the trial court and the facts the jury has heard. A couple of reasons. One is one assumes that is they've probably correctly pulled the most important facts because everyone's done their work here. Two, the jury made a decision based on those facts. And we don't want to negate a jury decision, lightly, right? So on appeal, they're probably going to look at that. But the good news is there's more substantial elements of law at stake here. Now they can look at this in a different, a broader context, looking at other areas of law. So a pattern should emerge from the treatment of facts in an office memorandum or brief. And we talked about this. Now I'll lay it out. First, you will state all important facts of the dispute at or near the beginning of the document. Up top, first thing, what's important? These are the important facts. You screw that up, you come to a different place, or your argument gets very weak. Second, in the discussion section of the memorandum or the agreement section of a brief, right? Argument section rather of a brief, after you have explained the legal rule applicable to a particular issue, you will discuss or argue whether relevant facts satisfy the legal rule. Okay, rule proof. This is the rule. These are the facts. This is the rule. And if you look at these cases and you look at the readings of the statute or whatever, you'll see that this is what the rule becomes. This is how the rule is defined. So we've proved that the rule means this by case law and so on and so forth. Then the next step, right, is going to be the rule app, applying the rule to your case. So you can see how this gets built, right? All right, and then you have to satisfy that. So if you look at the facts, so facts will show certain elements. So there are statutes, and some of them have elements. Well, they do have to have elements. I mean, some have several elements. For example, breaking and entering. Okay, so in order for burglary to happen, there has to be certain elements present. You read the statute, you break it up into the elements. So two of the elements are breaking and entering, right? Those have to be satisfied. Now, in that particular rule, you have to satisfy all of the elements. Sometimes only two of the three or four have to be satisfied for that rule to be activated. So let's just look at a breaking and entering. Keep it simple. What constitutes a breaking? I mean, I want to go into your house. If I break down the door, it's pretty obviously a breaking. I broke something to gain entrance. But what happens if I knock on the door's unlocked, and it swings open? Does that qualify as a breaking? If it doesn't, then we fail to meet that one element. But just let's say it does. We say hello, but we never go in. We never enter. Then we leave. We didn't satisfy that element. What happens if you knock on the door and it just opens? You say hello, no one answers, but lo and behold, against the wall is your rake that you loaned to your neighbor, whose house you're outside of right now, and you've been asking for months, can you give me my rake back? Oh yeah, I'll get it back to you, and they never get it back. Now you see it. Now the question is, it also involves a taking. You got to take something, right? Otherwise, it's vandalism up to that point. Or you can make an argument there. Anyway, well, how can you take something that's yours? Do you have a right to take it? Do you satisfy the element that that taking took place, right? If it doesn't satisfy it, and what are you going to do to prove that a taking has taken place? You're going to look at other cases, similar facts, where someone else went in and got, their shovel, or we would love for it to be a garden thing, or some implement to use outside because that's even closer to the rake. But let's just say you loan somebody, a book, and you saw the book on the counter there on the table, and you've been asking for it back forever, and you're never getting it back. Are you really taking your own possession? Does that constitute a taking? You have to look at cases where those things cropped up and say, well, here's how the courts interpreted that when you're really going in and retrieving something that's already yours. You can't really steal something that belongs to you. So did you satisfy the element or not of the taking? Sorry. So you do have facts that show intent. You'll have facts that don't show intent. So they give an example here on 102. We have no evidence that Con Motor Company, this is a case they had on earlier, which I didn't use, so it's sort of, you're not familiar with it, but it illustrates the point. We have no evidence that Con Motor Company maliciously intended to cause injury when it designed the backfire sports car. In fact, our notes of the May meeting of the board of directors show that the board members genuinely hoped that the risky design would not cause accidents. There's no intent there. They didn't mean to do it. They were hopeful that nothing would happen, but they didn't, and that tells you they didn't want to do it. So the intent is, it shows no intent. Now, facts showing recklessness, different thing, right? Different element. However, we do have evidence of recklessness. Con's chief engineer informed the board of directors of her opinions that placement of the gas tank near the rear exterior of the car would create a risk of deadly explosion in even minor rear end collisions. Yet the directors approved that design solely because it would save production costs of $200 per car, a trivial sum when compared to the $40,000 price of the car. That's not insignificant, right? They were saving very little, and there was high risk, knowingly creating a great risk of death or terrible injury to consumers without any socially significant justification for doing it. Suppose the car cost $1,000. That's 1/5 the price. A lot of people couldn't afford it. This way people can't afford it. Is the risk worth taking? Suppose we let people know there's a risk, right? Okay, so you see this we talk about duty of care and we talk about facts and the like, excuse me. The facts and the like, we have to think in terms of, the elements of the law. So another example, actual case. A couple, they have a house on a lake, and they go there every summer. They rent the house, doesn't matter. They go there every summer. And they have a son who is, 13. The neighbors have a son who's 16, and they also, summer there every single summer. And these kids get to know each other. In fact, the 16-year-old has a jet ski that since he was 13, he's been using, and the other kid at that point was like 10, if I've kept the numbers straight here, rides on the back, and he's been on these things forever. Kid reaches the age of 16. He says to his mom and dad, I'd like to get my own jet ski. And they say, sure, let's go down to the local jet ski place, and we'll look at some jet skis. So they go look at some jet skis, and they decide on a particular jet ski. And they buy it, but the person that's selling it, person that runs the store, owns the store, whatever, says, we have a class. It's a few hours that really teach, people that buy jet skis how to use it, what to do in case certain things malfunction, how to handle it safely. And the mother says, no, it's okay. He's been on these things forever, so there's no point in that. And then the guy behind the counter says, well, it's free. I mean, he said, no, that's okay. So the kid takes the jet ski out with the other kid, and lo and behold, the jet ski malfunctions that this kid's on, the 16-year-old, and crashes, and he gets hurt. Now the mother goes and sues, or wants to sue, the store that she bought it from and the manufacturer. Now it turns out the manufacturer knew that there was a small number of jet skis, 0.01%, where there could be this malfunction. There's really no way to detect it. Okay? And the owner of the store knew that as well. Mentioned taking the class and the like. So, who's really liable here? Well, the mother, right? She's the problem. She was offered, it was a small defect that, hardly comes up. The dealership was going to give the kid a class that would have covered, by the way, how to deal with that particular issue. But the mother said no. So she's the problem. She's responsible, right? She's the one that should have had a duty of care, okay? All right. Let's see here. Okay. By balancing and weighing the facts, right? That's important. You can reach at least some sort of, reasonable, qualified conclusion about whether a legal rule is satisfied. Remember, here's how this works. You've got a rule, you've got facts. You think that you could apply this rule, this statute, whatever, to these facts. So you need to prove that in similar cases with kind of like facts, the court interpreted the statute in this way, and that supports your argument. That's what you're doing, right? So if you extend, we're going to go ahead and we're going to extend on page 103, we're going to extend the illustration, right, about the previous section about the parties dispute with the anesthesiologist, right? An office memorandum might call for analysis of the following facts. 1. The anesthesiologist informed a patient scheduled for heart surgery of the advantages and risks associated with the 3 most appropriate anesthetics. On the basis of relative cost, the patient rejected the safest anesthetic in favor of generally safe and more widely used anesthetic, right? Rejected the safest anesthetic in favor of a generally safe, not the most safe, but a generally safe and more widely used one. Fact 2. The anesthesiologist administered general anesthesia without assistance before the surgical team had arrived and while the circulating nurse was occupied with another patient. Question is that an important fact or not? Are you supposed to have someone else there? And the like. Is that normal procedure? And there's a violation of normal procedure here. While the administering general anesthesia, the anesthesiologist concentrated intensely on gauges on her equipment that measured the patient's intake of the anesthetic. That's a fact. Is that a problem? Was that what they're supposed to be doing? Was it something else they were supposed to be doing? Was there a misreading of those instruments? Did she make sure those instruments were actually calibrated properly before? Okay, there's a whole host of questions. The anesthesiologist did not maintain visual contact with the patient or with equipment monitoring the patient's vital signs. Okay, we're getting into some deeper water here, right? As a consequence, she failed to terminate the intake of anesthetic until 10 seconds after the first visible signs of an adverse reaction. Now the question is, do the 10 seconds matter? If the 10 seconds don't matter, it usually takes a minute, then the 10 seconds are okay, it's 10 seconds. If it turns out that, you have to do it immediately. Within 2 or 3 seconds, the 10 seconds becomes an important fact. The patient suffered from a rare disorder they may not have possibly been able to know about, of the nervous system that produced a fatal reaction to the anesthetic. And had the person been watching the vital signs, they would have known that. They would have seen something, and they would have been able to intervene. The patient died within a minute of the administration of a general anesthesia. Is that normal? Is it a minute when you pull it off? So all these facts, this is what happened. This is the story. You have to take this story, pull out the important facts, figure out how you demonstrate they're important. And so all these questions arise from the facts, right? And there's a breakdown on page 103 of the facts in the first paragraph and what they suggest and so on, which I would suggest you actually look at. Okay? I would suggest that you actually look at because it would be very informative. All right. So now we're going to get into this concept of deductive reasoning, right? And what it is. Because we reason our way to these things. There's no hard and fast rule. Most of life, all that human beings have accomplished from, in medicine and in science and landing people on moons and stuff, is we kind of just observe. And we kind of figure things out. Oh, that happens when that happens. Or what if that always happens when that happens? And if it does, why does it happen? Maybe there's something that's doing it. Maybe it's the way you're doing it. We start asking questions. And eventually we figure things out, trial and error, that sort of thing. Right? Until you understand aerodynamics, you can't understand that that fast-moving air and slow-moving air have different weights. And if you can figure that out, you can figure out how to get wings on a plane to lift up the plane. And then also for them to be able to land the plane, right? So if you don't know that fact, you're sort of just, doing various things. And eventually you kind of look at things and, the apple falls from the tree, right? And there's gravity. Deductive reasoning is a conclusion derived from the law of your major premise and the facts of your minor premise. Reasoning, legal reasoning, you get premises, major, minor, and you get a conclusion of sorts or a resolution. And you take those premises, which you have to accept as true. You accept them as true, and you see what conclusion you get to that you can, you can rationally piece together. So I would read that. And also, there's a section on at the very end, summary, a legal problem, right? You should do the following. You should identify the issue, state the rule or rules that will help you resolve the issue, apply the rule to the relevant facts, rule app, reach a conclusion on the question of whether the facts satisfy the legal rule, rule application. Prove the rule, apply it. Now, identify the issue, that's I. State the rule is R. Apply the rule is A. And reach a conclusion is C. That spells IRAC, I-R-A-C. Sometimes when you're doing, you're submitting a brief, they want to see the conclusion up top as well as at the bottom. So it'll be CIRAC. It'll be conclusion, and then it'll be the issue, the rule, the applying of the rule, and the conclusion. Okay, it's important to keep in mind that all of this, what we're really doing here, is something very, very simple. Simple in terms of, understanding the process, a lot more complicated in actually effectively doing the process. And that is, we want consistency where words, which is what lawyers and judges rely on, right? That's the stock in trade. Words are ambiguous, right? And the context keeps changing. Now think about the complications there, right? The words are ambiguous in contexts that keep changing. That's a mountain to climb. And so law is a living and breathing thing. It's trying to always accomplish the same thing. Let's get consistency so people know exactly what we're talking about here, because this legislation, this regulation, is to address a problem. And we want to resolve that problem, whether it's a criminal problem or whether it's a civil problem or whatever it may be. We want to resolve it, if not resolve it, we want to address it. So the legislative body figures out as I said, expert witnesses, whatever, and they get to the point where they figure out, okay, look, this is what you got to do, right? This should work. And so they write the policy, and then something goes wrong, and gets into the courts, and the courts look at the facts, they look at the policy, which is the statute that deals with policy. They try to understand why this policy came about, what the legislative body meant by this term or this word. They try and piece all of that together, and as a result, come to some sort of determination, very narrowly. And then they've already defined words and the like, and they've tried to get rid of some of the ambiguity, but over several cases, those words will clarify a bit. And then the uncertainty factor, things change. Now along comes the same sort of case, but there's something unique about this or something additional that says you can't do it the way you did it before. So we're always, legislative bodies always trying to come to policy. That's the whole point of the law. I shouldn't say the whole point, it's an exaggeration. But that's the idea, right? Is legislative body writes statutes, laws to address problems, and that policy flows from that. Then the question becomes, there's exceptions to the way they've done that, or the words are confusing, and so the court have to take a more active role in defining those things. So, there's a great deal of effort is being made to keep things structured in an ever-changing environment with words that are ambiguous. If I said the word bad, you wouldn't really know what that is until you saw it in context, right? If I say duty of care, you don't know what that term means until you start seeing it in context. If I asked you to define words that you use every day, okay, chances are you wouldn't be able to do it. Most of us don't know dictionary definitions of words. In fact, it takes people to come together and figure out exactly how you should define something. And some words have several meanings. So even a simple word that we all may use, unknown, define it. You're probably not going to come up with a dictionary definition, but we do this all the time. We talk all the time. If you look at debate, using words. If you look at the debates in the legislative body, a lot of it's about words. I object to that use of that word because that means this, and that's going to confuse the public or what have you. We want consistency. The rule of law means we follow that structure. And without the rule of law, what we have is we have a violation of fundamental rights. And then ask yourself this: why would any individual want to place their life, by literally and figuratively, in a political structure or a governing body of a nation where no one knows what the rules are and no one has to follow them? Who is running to that place? One of the attractions of the United States is the rule of law. Now, it doesn't mean it's not corruptible. It doesn't mean it doesn't fail. It means that it's there, and it's our job to constantly work on it, trying to perfect something that's not capable of being perfected, but is capable of keeping things in order enough so that we know what we're responsible for doing, why, and how. And that we have a civil life where we can depend upon the law to keep everybody moving in the same direction in terms of what is acceptable behavior and what is not. The law is and its structure is the only way we know what's expected of us, and given our best and worst motives, what we're allowed to do. If there's no price to be paid for running afoul of that, then there's no law. And when you have a lawless society, again, you don't have a society. We come together and we agree on process so that we understand how things happen, so we can, be consistent with those things and have a better life. Right? I mean, freedom of speech has limitations because rights can't be absolute, or you have a breakdown. If everyone could express themselves in any way they wanted at any time they wanted, you don't have a rule anymore. Your freedom of speech, that right, must end where mine begins. That you don't have a right to say or do anything you'd like. Some people think that's what it means. It doesn't, because then you've got chaos. So laws are always restrictive by nature in some way. All right, that ends the lecture on 2B. We'll pick it up, give you about a week, rest of this week and next week to digest it all, and then we'll move on to the next lecture the following week. And we'll kind of try and move at that pace, a little slower at times when the material is a little bit more dense. This lecture took, combined 2 hours. So there's a lot to read, a lot to think about. And again, try and follow the process I've talked about where you're going to, take notes, come back and review the lecture. Also, if something's unclear, when I give you the page, also mark, timestamp it for yourself, so you know where to come back to look at it again and rewatch it. You don't timestamp things for yourself and say, okay, that happened at this point. If you want to go back and listen to that part of the lecture, you're scanning through the entire lecture trying to remember, okay, that came after this, so I should go further down. You got the timestamp the bloody thing. All right, good luck with it, and do the reading and listen to the lecture.